Tonight, we're not debating about immigration policy preferences, we're not analyzing politics, and we're not re explaining what the government froze or when. Tonight or today, we are asking a far more serious question. Has the United States government crossed from lawful immigration control into unconstitutional family separation? Because when U.S. citizens are prevented from living with their spouses, not due to fraud, not due to crime, not due to individualized findings, but due to national origin alone, the issue is no longer policy. It is law, it is constitutional law, and it is judicially reviewable. This episode is a legal dive. And by the end, you will understand exactly where the government authority ends and where the Constitution begins. Now, let's establish some principles here. Spousal visas, IR1 or NCR1, are not discretionary humanitarian benefits. They are statutory entitlements created by Congress, okay? Under the Immigration and Nationality Act, immediate relatives of U.S. citizens are explicitly carved out from numerical caps and backlog system. Congress did this deliberately. You wonder why? Because family unit is not included to immigration law. It is foundational to it. Now, Congress has repeatedly reaffirmed that marriage creates legal interest. Citizenship carries relational rights, right? Family separation is not a neutral administrative outcome. So this is why spousal visas historically receive priority treatment and individualized adjudications, right? So when the executive branch effectively nullifies the structure through nationality-based suspension, it is not merely adjusting enforcement, it is displacing congressional intent, and that is where legality begins to fracture. Now, you might be wondering, what is the difference? Oh, it's basically right now executive power versus statutory limits, right? The administration relies heavily on IN 212F, the provision granting the government authority to suspend entry of certain foreign nationals. This authority is real, but it is not limitless, right? Here is the legal distinction that we should understand. For Section 212F governs entry of foreign nationals. It does not erase statutory protections granted to U.S. citizens. So a spousal visa is not merely a foreign national seeking entry. It is a U.S. citizen asserting federally recognized family relationship. So courts have repeatedly warned against using general executive authority to override specific statutory protections. So in legal hierarchy, right, specific status or specific statutes override general grants of power. Congressional carve-outs matter. Executive proclamations cannot silently repeal law. This creates a serious separation of powers issues. If the executive can suspend congressionally protected family categories without any legislative amendments, then Congress's role in immigration law becomes advisory, not binding. So that is not how constitutional governance works, at least in a democratic nation that the United States claims to be. Now, the Fifth Amendment, the Fifth Amendment prohibits the federal government from depriving any person of liberty without due process of the law. The Supreme Court, which we're seeing right now, they're pretty for lack of a better word, useless to a certain degree, right? The Supreme Court has long held that marriage and family life are liberty interests, right? Not privileges, not policy benefits, liberty interests. So when the government interferes with those interests, it must satisfy substantive and procedural due process. Now, here's where we go into a problem now. No individualized findings, no hearings, no evidentiary showing, no appealable denial. A U.S. citizen spouse is effectively excluded through administrative paralysis, right? Legally, this resembles constructive denial, a concept court recognizes when agencies block rights without issuing formal refusals, which many of individuals are experiencing right now with that 75 countries that have been banned, frozen, all of that stuff. So courts have ruled repeatedly that the government cannot evade due processes simply by refusing to decide. Silence is not neutral. Delay is not harmless. Indefinite review is not lawful when liberty interests are at stake, which we are experiencing right now. Now, although equal protection is textually tied to the 14th Amendment, the Supreme Court applies its principle to the federal government via the Fifth Amendment. So, this matters because when the current framework threats or treats similarly situated U.S. citizens differently based solely on the nationality of their spouse, so same citizenship, same income, same marriage, same paperwork, different outcome. Nationality isn't always a suspect classification, but when it intersects with fundamental rights, courts do not apply blind differences. So, and marriage is a fundamental right any human has, a basic human right, right? A policy that burdens that right must satisfy high scrutiny or at minimum show a rational connection to the legitimate government interest. Blanket nationality based exclusions, especially when justified by generalized risk profiles, are legally fragile. They invite constitutional challenges, which many of these advocacy groups are trying to basically say and fight for the rights of those that they are in the process of bringing their spouse to the United States. So even if constitutional questions are set aside, the policy faces serious exposure under the Administrative Procedure Act, right? The APA. It requires agencies to articulate clear standards, to provide reasoned explanation, three, avoid arbitrary or um capricious actions, stay within statutory authority. So here we see no formal rulemaking, no published criteria, no public comment, no transparent justification for including immediate relatives. So courts routinely strike down policies for far less. So APA litigation does not require providing bad intent, only poor process, and this process is legally brittle. Now, we could see a reason why the courts may take this seriously. Immigration law receives differences but not immunity. When policies affect citizens directly, undermine statutory protections, implicate fundamental rights, operate through opacity rather than adjudication, courts must intervene, not always immediately, and not always successfully, but often enough to matter. This is why litigation is already forming, not just from the advocacy groups, but from citizens asserting constitutional injury. Now, this episode is not about whether immigration should be strict or lenient. It's about whether the government can quietly dismantle family unity without Congress, without courts, and without process. But if this stands unchallenged, it sets the precedence far beyond immigration. It redefines how much power the executive holds over citizens' personal lives. And that is a question the Constitution was designed to answer. I do want to highlight this episode is a legal analysis on the little that I know, public policy reporting. It is not a legal advice. Immigration law is complex and fact specific. Consult a licensed attorney for any of your individual cases. And if you haven't done so already, please go ahead and click that subscribe button, click the notification so that way you are up to date with everything that we're posting. Until next time, Assalamu alaikum.